Thank you, my brother. Earlier on, Student Center, Tottenham Hall. Well, ladies and gentlemen, I'm very happy to be here. Thanks to the organizer of this program, His Excellency Jeremiah Solomon, Liberian Ambassador to the United States, Madam Senator, Mr. Superintendent, my fellow Liberians, ladies and gentlemen. I visited Liberia recently, and the dual citizenship topic has heatedly discussed. I got in one of those discussions and trying to make the case for dual citizenship. And there was this argument against dual citizenship. And the person said, I said, huh? And I said, well, but Kwame, look, there are many Liberians who are 5 members of the U.S. military. They're in the Marine, the Navy, the Armed Forces, and the Army. What if Liberia and America go to war now? I said, oh. No, and this is serious. It's serious. The president said, was it serious? They said, what if America and Liberia go to war now? Those Liberians who are in the U.S. Army, they got all our national secret, they can be threat to all. I said, oh. But this is what passes sometimes for rational discussion about what I think is a very, very serious issue. The issue of the ban, the prohibition on dual citizenship. And today what I briefly like to do is look at the policy, argument for or against, then more fundamentally focus on, to the extent there are any legal arguments against the prohibition against dual citizenship. And then some broad recommendations for the future which would draw on some of the things that have already been said. You know, the Alien and Nationality Act, Section 22, is the most relevant provision of the law here. It says in relevant part that a Liberian who is otherwise born a Liberian loses his citizenship if 1, he naturalizes in another country, 2, he votes for the president or the leader, the sovereign of that country, 3, he voluntarily serves in the armed forces of that country, or 4, finally, he renounces his citizenship before a Liberian diplomatic or consular officer in a manner prescribed by the Liberian Secretary of State. So those are the 4 grounds for automatic revocation of dual citizenship. The statute, in fact, provides that the government has no duty to go to court to prove that you have renounced. Doing any one of those 4 things serve as automatic renunciation and result in the loss of dual citizenship. Now, exclusivity of nationality is not new or unique to Liberia. It traces its roots back in history when people were subjects of kings, and you were perceived as being the subject. You can't be the subject of more than 1 king at one time. And over time, it became embedded in statute. And even in the United States, as late as the 1960s, you know, serving in the armed forces of another country, or even voting in the elections of another country, automatically resulted in the loss of citizenship. But times have changed. The antipathy towards dual citizenship has ended virtually in many countries. In the U.S. now, as many people have said, you know, becoming citizen, national of another country does not result in the loss of a U.S. citizenship. In fact, the only thing that can result in the loss of U.S. citizenship is you effectively renounce U.S. citizenship. Many countries around the world, Mexico, you know, New Zealand, you name them, India, Thailand, and in Africa, you know, Ghana, Tunisia, Tanzania, have all recognized the value of dual citizenship. Cape Verde has taken the lead. In Cape Verde, their citizens who live outside, in fact, have, I think, 2 seats reserved in the national legislature for them. The common thread I run through this country is that they're more developed than Liberia, so they must be doing something right. And you've gone through the policy rationale here for why dual citizenship makes sense. We live in a globalized community. We travel. You know, we acquire new skills. We acquire new wealth. Loss of our citizenship discourages that kind of thing, which benefit the home country. And the policy rationale is there. It's undisputable that as a matter of fact, it benefits the individual, it benefits the nation. So what I like to do quickly then is to look to the extent, and let me say this, it is not in and of itself a constitutional argument. You do not need to amend the Constitution to change this prohibition on dual citizenship, because it is purely in the statute, a law. All that needs to be done is for the legislature to pass a repealing statute, a statute that repeals that provision, Section 22 of the Liberian Alien and Nationality Act of 1973, that prohibits dual citizenship. And case will be closed, matter solved. But to the extent we cannot get the legislature, and I think we should continue working on this, and we'll discuss how to repeal the statute. Are there other avenues left to us? Is there a basis to challenge the ban and prohibition of dual citizenship on legal constitutional grounds? I suggest that there's a strong argument that the statute rests on a rather wobbly constitutional foundation. Why? Citizenship is a matter of fundamental right. Under Liberian law, and under the various treaties to which Liberia is signatory, the right to citizenship is a fundamental right. As a matter of constitutional law, to deprive a person of a constitutional right, the state must show a compelling national interest that it seeks to protect. One. Two, it must then show that the avenue it is chosen to protect that national interest is narrowly tailored as much as possible. Thus, the question then presents itself. Does the state have a compelling national interest in imposing a prohibition on dual citizenship? Well, as you may hear, one of the interests that may be argued is that dual citizenship may threaten our national security. I don't think you agree that that holds water. The other argument that I hear often is that, well, you know, you got these people come from abroad, they break our laws, they commit corruption or whatever, and they can flee back to the United States. And there they're citizens, they will be protected from extradition. The argument that somehow somebody who voluntarily accepts and benefits from Liberian citizenship can run afoul of the law in Liberia and then seek refuge in the U.S. because he claims to be a U.S. citizen is simply far-fetched. So I think the statement is hard-pressed to present a compelling national interest that will warrant or justify as a matter of constitutional law the prohibition of dual citizenship. There is the secondary argument. Even if there is a national interest to be protected, as the state satisfied the other prong of the test, that is, it's the avenue it's pursuing to protect that national interest narrowly drawn, narrowly tailored. See, the emphasis there is that it can't be broad that it impinges on a right that it otherwise should not. And I submit, I do not think it is narrowly drawn. For example, if the state can make a showing that this particular person who has dual citizenship, for some reason, it's likely a threat, has committed treason, then okay, understandably then you can bar that person. But a prophylactic bar, a prophylactic ban on the exercise of dual citizenship, without more, I think fails to satisfy, on the one hand, the compelling national interest test, and on the second hand, whether the avenue chosen to protect that national interest is narrowly drawn. There are other grounds on which this statute can be challenged, much more stronger grounds. And one of those grounds that I'd like to discuss briefly is contained in section 20.1 of the statute. Section A is a person who is of Negro descent or born to someone of Negro descent in Liberia and subject to the laws of Liberia, a citizen of Liberia. We all agree with that. By the way, I want to note that parenthetical subject to the jurisdiction of Liberia is meant to exclude diplomats, because you can be born in Liberia, your children, but they're not subject to the jurisdiction of Liberia because they're diplomats, so they're not citizens. But that's the first place. Then the second, B, this person can be citizen now, born outside Liberia, whose father, 1, was born a citizen of Liberia, 2, was a citizen of Liberia at the time of the birth of such child, and 3, had resided in Liberia prior to the birth of that child. Let me say again, you are a citizen if you are a person born outside Liberia whose father was born a citizen of Liberia or was a citizen at the time of the birth and had resided in Liberia before the birth of the child. What's wrong with that section?
Contradiction.
Ah, beautiful, right? Does he mention the mother? There's a canon of statutory interpretation called inclusive unius as exclusive ulteriors. The inclusion of one is necessarily the exclusion of all the others. And if you went to court with this argument, I would be, look, the drafters of this statute knew how to include who they wanted to be included. They included only fathers. To the extent they did not include mother, they meant not to include mother. But then there's segregation here. Discrimination on the basis of gender. Isn't so? And as a matter of constitutional law, to segregate on the basis of gender, the state must show an important interest. It is less a more stringent test than the fundamental right test. But it is still a difficult test. To discriminate on the basis of gender, you must show, the state must show an important interest. And then it must show that the avenue or the law it is put in place to protect that interest is rationally related to the goal it seeks to achieve. Pray tell me, what important interest can the state have in discriminating on the basis of gender? So someone who's born to a Liberian mother cannot be citizen, whereas someone who's born to a Liberian father can be citizen. I submit it cannot pass constitutional muster on equal protection ground for the Lord. And if challenged in court, I submit this statute will and must fill this provision of the statute. There's another provision I'd quickly like to touch on, and that's 2130 of the statute. It says a woman of Negro descent who marries a citizen of the Republic shall not become, by virtue of such act of marriage, a citizen of Liberia. Such woman must be naturalized if she otherwise qualifies. So what is it simply saying? That if you marry a woman who is not a Liberian, she's not automatically citizen of Liberia by virtue of your citizenship. She must naturalize. But at least it provides her an avenue, a pathway to citizenship. But notice something again. This section again is silent as to a woman, as to a non-Liberian spouse of a Liberian woman. Those Liberian men knew how to discriminate against. And so again, the statute is unconstitutional on its face, because again, it discriminates on the basis of gender. And as I've said, the state cannot meet the test for surviving strict scrutiny, the constitutional standard of review, strict scrutiny. That is, it cannot show an important national interest that it seeks to protect by discriminating this way, and it cannot show that that interest, or that this statute is rationally related to the interest. So I think there are grounds, ladies and gentlemen, on which this statute can be attacked constitutionally in the courts if we cannot succeed in getting a legislative repeal. First, I submit there is a strong argument that it violates the fundamental right of people to citizenship, not to be deprived of citizenship, a right enshrined in treaties to which Liberia is signatory, that the state cannot show it has a compelling interest and that it is taking a path that is narrowly tailored to protect that interest by prophylactically prohibiting dual citizenship. Second, I think the statute on its face discriminates unconstitutionally against women. Women of Liberian descent with Liberian citizens who born children outside Liberia. It also discriminates on its face against women in that it does not give their spouses an avenue towards citizenship as it gives the spouse of Liberian men. So, what do we do? Well, a lot of this has been discussed. I know that there's one case pending before the Supreme Court. One avenue is to join that case. One avenue is to file a new case that fleshes out the issues as I've laid them out here. And seriously, put the court to the test. Put forward a legal argument and force the court to decide this issue. I think a well-written brief, a well-argued brief, along the lines we discussed, will carry the day before any fair court of justice in Liberia. The second thing we do is to broadly organize ourselves. You know, we talk about all the good work we do here. You know, the remittances, all the organizations. We need to have conferences like this in Liberia. We need to use the airwaves, the radio, the television. You know, the Lofa County Association, I know you're doing things back in Lofa. The Bassa County Association, you're doing the same thing. The high school, BW Higher, Cathedral, they're doing the same thing. Let's put together on a yearly basis, and I've worked through EULA and the heads of all these organizations, and put together on a yearly basis a compendium of the different projects we in the diaspora are undertaking in the country. Let us put together, you know, what does Western Union say about our remittances? Let's put that together in this one compendium. What investments are we making on the ground? Let's put that in this compendium. You know, I'm a lawyer, and there's a thing that all lawyers are crook except your lawyer. And people in Liberia don't appreciate they appreciate, my family appreciates what I do for them. Your family appreciates. But they don't appreciate collectively what we do as a whole. And thus they can't appreciate the value we bring, the immense intellectual and financial value we bring to our country. And so if we can put all we're doing separately into one compendium on a yearly basis, and a big forum in Liberia, well, we present it, we're not bragging, we're not boasting, but this is what we're doing for our country. I think it will have an impact on the course of the debate. You know, I like to say that we didn't choose to come into exile. Many of us were forced into exile by the war, by circumstances beyond our ability. I dare say some of us would not be standing before you today alive, and we chose to remain in Liberia for a variety of reasons. And so the fact that war was forced on us, and we had to flee for our lives, does that deprive us of our Liberianness? Isn't it ironic? And in many ways, the people responsible for the war that forced out of our country, and to better our lives, forced out maybe in some cases to attain citizenship. Isn't it ironic that some of them are still championing now a ban on prohibition, a law that will make us, that will deprive us of our citizenship, because by their very act, they force us out of our country? That cannot be fair, it cannot be right, and it cannot survive the test of time. I submit to you. And I think that discussion brings into relief the larger passions and issues when it comes to national unity. Why are we cleaving ourselves once again? The brother, the superintendent from River says, you know, brilliant when went through the historical analysis of divisions that have plagued our society, our country. You know, one time we were separated on the basis of the color of our skin. Then the other time we were separated by the basis of whether we were country or Congo or whatever you call it. Then in more recent times, we've been celebrated on the basis of the tribe from which we've come from. And we know every time we've listened to those voices of extremism that have separated us, we know what history has taught us. Produces seeds of enmity that span the generation, huge economic and social dislocation. Yet today, we want to divide ourselves on the basis of dual citizenship, those who came, those who stayed. The problem our country faces are too immense. How do we break through from poverty that continues to stalk us? Is development beyond our reach? What kind of innovative policies we can bring to bear in health and education and agriculture? These are the issues that should be consuming us. Whether we're here or whether we're in Liberia. Whether we're citizens of America or Liberia or whether we're citizens of Liberia only. These are the issues that should be consuming us as Liberians. Not whether we left America and we came here to survive, while we retain our Liberian citizenship as a matter of technicality. Some people assume American citizenship. We're putting ourselves to waste. We're losing the immense abilities and resources of people here. And so, I say to you, you know, I was in Liberia recently, and I was reminded of my Liberianness. You know, walking down Broad Street, you know, the smell and feel and taste of the place. You know, talking to people who I haven't seen for many, many years. The intangibles of blood, history, culture, that gave true meaning to the saying that home, country, is where the heart is bound to. Whatever happened, we can never lose our Liberianness. And let us remember the words of our national song as we go about this endeavor. And it is not only for us, those are people here who may have dual citizenship, that is in the larger interest of Liberia, and that in union strong, success is sure. We cannot quit.
Ladies and gentlemen, thank you very much.